Hi, everyone. Welcome back to House Healthcare. It's still Wednesday, and we're going back to S47 today. And I think after our conversation yesterday, I asked Katie to maybe let's step back and go over some background and not focus on the language or the bill itself today. I want to have time to go over kind of what all this means, what happens today, walk through Katie's knowledge, which is great. And then we will come back to language another day. So with that, I'm going to turn it over to Katie.
Okay, thank you. Katie McGlynn, Office of Legislative Counsel. So I'm going to share with you a presentation I put together several years ago, and I didn't realize quite how long it was until I realized I hadn't updated the date. So this is a 2017 report, but I think it will still serve our purposes today. Let me put it up on the screen. So the idea here is that when you're looking at 7505, you're seeing like one little window in time of a larger, longer process for individuals who are determined in need of mental health care in an inpatient setting. So this presentation is designed to sort of give you the big picture and show you where the warrant piece fits within that. And hopefully that will ground the committee a little bit about where and how 7505 works. Okay. Okay. So this chart helps me, or this picture helps me think about how people may find themselves at a hospital for mental health care. So first, they could come in voluntarily. We also have individuals who are coming through the criminal justice system. That's our forensic examination in Title 13. And when we looked at S89, those are the folks we were talking about coming through what I call the criminal justice door. And then there are sort of these two avenues up at the top where individuals who are not criminally justice involved at the time, they are not voluntarily coming into a hospital. They're coming in involuntarily. How did they get into the hospital? So I'll start with the box on the right first. We have our application and certificate for emergency exam. So this is the situation where the physician is available to certify that the person needs an emergency exam, and the person comes into the hospital that way. And then the box on the left, this is what we've been talking about in S47, the warrant and certificate for emergency exam. So the physician is not available, and a warrant from a judge is sought to be able to bring individuals into the hospital for the emergency exam. So those are sort of the different avenues and ways that folks are coming into a hospital for mental health care. So first, the application and certificate for emergency exam. So this is the box that was on the right. This is the box where the physician is available. So a person is held for admission at a hospital for an emergency exam to determine if that person is a person in need of treatment. It's in quotes because it's a statutory term. There's a standard attached to that. And it's criteria that when an assessment is being done, the clinicians are looking to see if the individual meets that standard. And eventually a judge is looking to see if a person meets that standard. So the authority to transport and admit the person into a hospital for an emergency exam is under this section, and that includes an application by an interested party and a certificate by a person who is not the applicant.
So the applicant could be a family member.
It says physician, but do you mean?
No, it means physician. So there's a first certification and a second certification. Second certification is sort of synonymous with our emergency exam. The second certification is done by a psychiatrist. The first certification is done by a physician.
All right.
Yes, Katie, is this a voluntary or involuntary?
This is involuntary.
This is involuntary.
Yeah. Okay. So again, the authority to transport a person and to admit a person into the hospital for that second cert, the emergency, which is the emergency exam, is the application and the first cert by a physician.
Can I ask? What's an interested party in this case?
It could be, do I have that on the slide?
Application
Number one,
by-
under number bullet two.
Too, by an interested party. Potentially a family member, potentially if a clinician who is seeing the person, potentially a law enforcement officer who is seeing the person. I would say those are the interested part,
People's,
people, yeah. Clinicians around the room might have other additions to that list.
HP and
Yeah, clinician. And so then the application and the certificate must state the facts and circumstances that constitute the need for the emergency exam, the second cert. So if that physician is not available right away, we have this alternative option, which is the warrant process. So the application for a warrant requires that we have an emergency circumstance, the physician's certificate, that first cert is unavailable without serious and unreasonable delay. There's personal observation by a law enforcement officer or mental health professional that the person's conduct constitutes reasonable grounds to believe that the person is a person in need of treatment, and the person presents an immediate risk of serious injury to self or others if not restrained.
I'm sorry. When you say physician, are you meaning psychiatrist or is that an emergency room doctor?
It could be an emergency room
Okay.
doctor. This is.
It could be either.
Well, when we talk about the emergency exam, we're talking about a psychiatrist.
That's what I'm getting confused about. I think.
But to get the person in for a first certification, a first exam, that can be done by a physician.
Okay, thank you.
and this could be any physician. This could be their primary care physician for a warrant, right? This could be
Yeah, it doesn't specify, so it could
So it
be,
is not a psychiatrist, doesn't have to be a psychiatrist. Great, thank you.
The first certification, it is physician, it can't be a nurse practitioner or a physician
statute
assistant.
says physician.
Okay.
not changing that today.
Michael,
Okay.
We should have.
So we're still considering the warrant avenue to coming in for voluntary care. So as we know, the law enforcement officer or qualified mental health professional will seek a warrant from a judge. The judge may order the person to submit to an evaluation by a physician. And if satisfied, if the judge is satisfied, the physician's certificate is not available without serious and unreasonable delay, and probable cause exists to believe that the person is in need of an emergency exam, then the warrant would be issued. So,
Keep going. I'll ask for questions.
Okay.
Just keep going and I'll.
I'm sorry.
It's okay.
upon arrival at the hospital, an evaluation is conducted as soon as possible by a physician. That's the first cert. And there are two possible outcomes after the physician does that first certification. The physician might certify that the person is a person in need of treatment, in which case the person is held at the hospital for an emergency exam, the second cert. Or the physician does not certify that the person is a person in need of treatment. The physician doesn't think the person meets that criteria, then the person is discharged.
Art?
Yeah, can you describe the process of the warrant request? In other words, an officer is dispatched because they've heard something going on in the street. Is it a phone call that starts the warrant process? I want to say warranty. Keep the warrant, start the warrant process, or how does that get done?
So that level of detail is not in statute, but I think the testimony you've heard is that it's often a phone call that initiates that process.
Yeah, so this is the process as it
Yeah,
is
right.
in statute. And let's work through that. If it's how it happens in the field, write it down, because we do have some people in the room we could potentially column.
Okay. And so here is our emergency exam, the second cert. So the authority to hold the person, so at this point, we're already past the warrant. The person has already been deemed that they're a person in need of treatment at the first cert. So we've kind of moved past. So if you remember that first picture I showed you with the 4 arrows going into the hospital, at this point, the folks who were in the top 2 boxes have sort of ended up in the same place. So now it's the same process for them here on out. So the authority to hold a person for admission to a hospital for an emergency exam is the application and the certificate. That was the box up in the right-hand corner, or the warrant and certificate for the physician evaluation. The next step is the emergency exam is conducted by a psychiatrist as soon as practicable, but no later than 24 hours after the initial certification. The psychiatrist does not certify that the person is a person in need of treatment, the person is discharged. If the psychiatrist does certify that the person is in need of treatment, the person is held for 72 hours. A few things can happen within that 72-hour window. So the hospitalization continues, the hospitalization is terminated unless the person accepted voluntary admission. So at that point, the person might just say, yes, I'll voluntarily go to the hospital. Or the commissioner would file an application for involuntary treatment, and the person would continue to be held pending the court's finding on that application for involuntary treatment. Then there's an opportunity for a preliminary hearing. So within 5 days after admission for the emergency exam, the patient may, but doesn't have to, request a preliminary hearing. The hearing must be held within 3 working days of the request. And the hearing determines if there's probable cause to believe that the patient is a patient in need of treatment at the time of his or her admission. So if probable cause is established, the person is held to go to the proceeding of commitment. If probable cause is not established, the person is discharged. So this is like an optional interim step that the person could choose to have a court look at their case and determine if they should continue to be held for the actual full commitment hearing, or if the court finds that no, there's no probable cause, we don't have to continue holding this person.
Brian, but hold on. So, but does someone have, like, I could just say, yes, I'm fine. I don't need to request a hearing, right?
That you don't have to have this type of hearing. Yes, it's optional.
Okay. Brian?
That law changed a few years ago.
Has it?
Yeah, and so now it's required.
Can you,
Sorry, Kristen Chandler, from Therapy Partners and T2. Every case gets reviewed by a judge for probable cause within 72 hours of the Department of Mental Health's filing. It's automatic, sure.
And
then you still have an option for this 5 days as well, or no?
Yes.
You still have the option. Okay.
I wanted to ask if you can go back a slide too.
You can challenge the judge's finding.
Okay.
I just want to go back a slide to put it in perspective.
Okay.
That once a person has had the second certification, there has to be an exam within 72 hours, right? No, I'm sorry. You can be held for 72 hours. What I wanted to just get some more clarity on is that what happens at that 72 hours if a person, it says on here that if a person's they've accepted voluntary admission, then they're voluntary at this point. Everything else that you're saying falls away, correct? Like if a person is voluntary at 72 hours, there's no further review by the courts. They're just in the hospital. They can leave if they want. If the staff feels like they can't leave, they'd have to reinitiate this.
Yes.
I just want to be clear for people that like once you're voluntary, a lot of the stuff that we're reviewing doesn't apply unless you try to leave and they don't want you to, and then they have to reinitiate all this.
Yes.
Okay. And then the other thing is, I did think there was something about what Kristen Chandler just said, so I appreciate you saying it. I thought there was some other review in there, so I'm glad you clarified that.
So I don't recall that change, so I will update this and submit it to you.
Okay, great.
And I'm wondering what else might be out of date.
That's okay. I'm sure,
We're here to remind you.
I was gonna say, I am sure people won't be shy.
That's just 7612A. And I think.
Do you remember what act it was?
I don't.
Okay, I'll look it up.
It was, I think, 2013.
2013, okay. Well,
No, this is
this
after
is a
that.
2017 slide.
I know.
Okay, I'll have to look into it. Thank you.
Alyssa, just to clarify, so you can go through this whole process and then the person can say, okay, I'll be voluntary.
Yes.
And then 5 minutes later, it can say, never mind, I'm out of here. And they can leave and the whole process has to start all over again?
If at that time, so the person can choose to be there voluntarily, and then the person may say, I'm here voluntarily, I'd like to go, and the person's providers who are treating that person might say, actually, we think you meet the criteria for involuntary commitment. So if you choose not to be here, we're going to go through this process of an application for involuntary treatment for commitment.
But do they have to start all over from the beginning again?
No, they start sort of here where we're going to move forward with
Okay.
the application for involuntary treatment.
And they can keep a person in the hospital during that against their will, but like, it does happen that people become voluntary and then hours later, they're like, never mind, or they're like, I'm leaving, and then the staff's like, no,
Maybe not.
and then it is a lot of work.
Okay.
But I will say that it guarantees that people's rights are respected, and so as a provider, I don't challenge that. Like, I think that we need to make sure people have like due process. This is my opinion.
Okay. Yep. So we talked about the preliminary hearing. Then we have the application for involuntary treatment. So this is the application to hold a person in the custody of the Commissioner of Mental Health. So the application must contain a written application filed by an interested party and at least one of the following, the physician's certificate that the physician examined the person within 5 days of the date of the application for involuntary treatment is filed and believes that the person is a person in need of treatment, or the applicant's written statement that the person refused the physician's exam. Next, once the application is filed, the court is responsible for appointing counsel to the person, transmitting copies of the application, physician certificate, and notice of hearing to the person, counsel, guardian, and state's attorney. And as soon as practical after that notice, the court may authorize exam of the patient by a psychiatrist other than the certifying physician. And we have a hearing date. The hearing must be held 10 days from the date of the application for involuntary treatment's receipt by the court, or 20 days from the date of the application for involuntary treatment's receipt by the court if the psychiatric exam is ordered under 7614. And then the court can either grant either party a 7-day continuance for good cause, and it can grant one or more additional 7 days continuances if certain conditions are met.
So is the individual in the emergency room all this time? Because it seems like there could be a lot of time, like 5 days here and 7 days there.
Better question for the clinicians in the room, but my understanding is that sometimes treatments starts if there are beds available.
So they might get admitted to a psych unit,
They might, if there's a bed available, yes.
but if not, they'll be in the ER. Likely.
There'll be somewhere waiting, yes.
Right.
I would say that hopefully a person gets a bed in the psych unit.
That would be
We
ideal.
all know
Right.
Right.
how dire the situation can be, so.
But I'm just saying, I know, put that bed problem aside. If there is a bed, they will be moved out of the ER. That would be what would happen.
It has to be a certain kind of bed, though. It can't just be any old bed. Like, it has to be the higher level, yeah. But I just want to, I know this is 47 and not whatever, the 36, was 36 the staff getting attacked one. But you can imagine why when people are stuck in an emergency room involuntarily, why that might increase violence.
Sure.
Yeah.
So Katie, can we, I think I'm struggling with the time, the 72 hours and the 5 days. So can you, without everything else, can you just kind of explain potentially So the person is in the emergency room. We have the authority to hold the person. And then, can you just,
Yeah, so I would also say that some of the timeframes are overlapping a little bit.
okay.
So I would say it's not necessarily like each timeframe stacked on top of each other. So let me go back. And I don't know all of these off the top of my head. So first we have the emergency exam, as soon as practical, but at least within 24 hours.
Okay.
And then after the emergency exam, we have a 72-hour window. And we know that in that 72-hour window, either we're filing an application to hold the person or the person is voluntarily being admitted.
Okay.
Then within 5 days, we have that first hearing.
And is that 5? Sorry.
Within 72 hours, we have the probable cause review.
I have the probable cause review somewhere else. Hold on. For each AIT filed, the family division must conduct a review to determine whether there is probable cause to believe that the person was in need of treatment at the time of his admission.
So we'll
me-
come back to that once you verify that, Katie, and where it falls in the process.
Okay.
Oh,
This timeline.
okay, that might,
Oh,
great.
So this is, maybe we're talking about two different things because I have the optional preliminary hearing and then the probable cause review. And the probable cause review, I think I have this arrow to show that it could happen earlier in the process. So anyway, we have this first stop, and this is sort of the person coming in for establishing that they need an emergency exam. So warrant, application, or they're coming in through the criminal justice system. Then we have the emergency exam. And I have this optional preliminary hearing, which I'm wondering if maybe we'll circle back after. Then we have an application for involuntary treatment. There's also this avenue for an expedited application for involuntary treatment, and we'll look at that. There's a probable cause review, and I think the timing of the probable cause review could shift depending on various circumstances. Then we have the application for involuntary medication. Sometimes the application for involuntary medication and voluntary treatment are combined in certain circumstances, or could be combined in certain circumstances. We also have this application for continued treatment. So that's the person has been on an initial order for either hospitalization or order of non-hospitalization. When the term expires, the commissioner thinks that the person needs continued treatment and they might file for that, either in a hospital or a non-hospital setting. And I have these two little blue arrows showing that it doesn't matter the order. So somebody, they could file for application for involuntary medication at different points.
Does the act or the S-47 just go up to the second bullet?
It's really the first
Just the
bullet.
first.
Yeah.
Once they get to there, then what we're reviewing right now is not in the bill.
Yeah.
Okay.
It's literally 1/3 of the first
Bullet.
thing.
Not bullet.
1/3 of the first.
Stop.
Yes.
It's just getting the person to assess if they need to move to that second step, the emergency exam.
Yeah, I think it's helpful to understand.
Oh, no, totally. I'm just like wondering how much, like, I can't hold it all.
Yeah.
So- I was like,
Okay.
2 minutes.
When the individual's transported, say by law enforcement, do they turn over, it's literally, this person comes in and someone from the hospital or emergency room takes them and then the officer goes away?
So there's language in 7508, let me think, that says that once a person has been found a person in need of treatment under either the first or second cert, that's when they begin temporary custody in the Commissioner of Mental Health's temporary custody. So before that, if they're coming in by a warrant, it would seem that they would be in the temporary custody of the person bringing them in, the law enforcement officer bringing them in, until that first cert or whenever they get that determination, person in need of treatment.
Okay, until they get the warrant back saying it's approved.
No.
I thought I remember them saying if they didn't get the cert, then they were let to go home,
They are
transported.
discharged.
They were discharged, but
Mhm.
transported by the people that brought,
Yes.
To the place where they were.
where they were.
Kristen, do you want to add anything?
Well, I just want to answer your question. It really depends on the hospital.
Okay.
If they, and there's that communication piece between law enforcement and the emergency department personnel. If they feel safe with the officer leaving, or if they may have their own security department there,
Okay.
the officer will just,
I didn't know what the protocol
sometimes
was.
they'll stay, but if hopefully that communication so that everybody feels like, okay, you got them now, they're your patient. Technically, once they go in the PD, they become the hospital's patient.
Okay, that's kind of what I was getting at. All right, okay, thank you. Yeah.
Okay. Should I go back?
Yeah, let's go back and.
Back in time.
Um,
She said flow, when I said flow sheet last night, look at slide 17. That's a flow sheet.
on here?
Yeah.
Oh, you know what? That is, I can't take credit for that one.
Well,
All wrong.
oh no, it's all changed, but it's
This
really
is-
impressive. Look at that.
This is from.
That's what I was talking about yesterday. We need a flow sheet.
This is from Legal Aid. I used their document. So anyway, let's go back. I know it is impressive, but it is, I think, probably subject to change.
It's very complicated.
Okay,
Well, that's why we kind of were tripping all over ourselves.
so,
Can I also just add something in here?
Mm.
I think, as Leslie just said, we're kind of tripping all over ourselves, which I feel like kind of are with this one, so I apologize. But I think there's a lot of policy, so what's in statute, and then what's happening, and they may not be aligning. And that's, so this is good that we're walking through this policy, what's in statute, and then hearing some, what's happening in practice. We're gonna come back to, is all this lining up how it's supposed to line up, which is part of S47.
okay. So we just looked at what the application for involuntary treatment looks like. And there's also this option for an expedited application for involuntary treatment. So there can be a motion to expedite the hearing. It can be filed by an applicant or the person who is certified as in need of treatment. The court may grant an order for expedited hearing on the application for involuntary treatment if the person has received involuntary medication during the past 2 years. And based on the person's response to previous and ongoing treatment, there's a good cause to believe that additional time will not result in a person establishing a therapeutic relationship with providers or regaining competence. Or the court shall grant the order for an expedited AIT hearing if the person demonstrates significant risk of causing the person or others serious bodily injury even while hospitalized, and clinical interventions have failed to address the risk of harm to the person or to others. So under those situations, the court can expedite the timeline. The hearing would be within 10 days of the order being granted for an expedited hearing. And the court cannot grant either party an extension under this expedited process. So then I have a chart comparing expedited versus the traditional process. So all applications for involuntary treatment are considered by the court. And then we have the expedited application for involuntary treatment. We have what we just went through, the situation which the court may grant an expedited or which the court shall. So in one circumstance, the court has discretion. In terms of timeline, under the regular timeline, the hearing would be within 10 days from the date of the applications received by the court, or within 20 days from the date of the applications received by the court if a psychiatric exam is ordered. And then the hearing on the expedited hearing would be within 10 days of the court granting the motion. And then in the regular process, there could be a continuance for good cause or for certain circumstances, and there are no continuances under the expedited process.
Right.
So 10 days doesn't seem very expedited. So In the expedited process, does that mean that it's regardless, it can be granted regardless of whether a psychiatric exam is ordered?
I believe so. And I would feel free to take friends from around the room tell me, but I'm trying to remember back the conversation when this was created. And I think my recollection is that there's almost always the psych exam ordered, which means that the regular process is almost always closer to the 20-day window. Okay, and there is a probable cause review. So for each application filed, the family division must conduct a review to determine whether there is probable cause to believe that the person was in need of treatment at the time of his or her admission. So this review is based on the emergency exam application and accompanying physician certificate, if there is one, and the application for voluntary treatment. And the review must occur within 3 days of filing for the application for involuntary treatment. So as soon as the application is filed, this triggers a 3-day window in which the court is reviewing the probable cause to have the full commitment hearing. If a probable cause is found, the person is held. If it's not found, the person's discharged.
So this is like 101, I don't know. Does the individual get taken to court? When you say family division conducts a review, that's not in court, that's outside of court.
So my understanding, and again, the folks on this side of the room will correct me if I'm wrong, that the probable cause review is a paper review. So there's not, like, the judge is just looking at the document submitted, and that the actual proceeding, there would be people coming into court.
Okay, thank you.
You're so right on.
I keep watching you nod, so I'm going,
Okay.
that's good.
And Kristen nods, I'm in good shape. Okay.
Yeah.
So application for involuntary treatment, the hearing and the outcomes. So at the hearing, the state has the burden of proving the case by clear and convincing evidence. Initial court orders of hospitalization and non-hospitalization last 90 days. So the first order, the initial order, if a court decides that the person needs involuntary treatment, is 90 days. So the court could find that a person is a person in need of treatment at the time of admission or application, and the court finds that the person is in need of further treatment at the time of the hearing. If so, the court may order either hospitalization, or I'll just skip that, or an order of non-hospitalization. So we have two types of orders. An order of hospitalization is what it sounds like. The person is ordered to receive treatment in a hospital setting. Order of non-hospitalization, the person is still in the custody of the Commissioner of Mental Health, but they could be in different settings. So they could be committed to a facility like the Secure Residential Recovery Facility and receive treatment there. They could be in the community, living in their home with certain parameters around their care and treatment, and they would still be under the custody of the Commissioner of Mental Health. If the court does not make those findings, then the application is dismissed and the person isn't held. So after that 90-day window of the initial order, potentially the commissioner could determine that the person is still a person in need of treatment. In this case, the standard is a person in need of continued treatment. So prior to the expiration of the order of hospitalization or order of non-hospitalization, the commissioner would apply to the court for a determination that the person should still be held for continued treatment. The application for continued treatment must contain the reasons for the commissioner's belief, the statement describing the person's current treatment program, and the results of the current course of treatment. If the commissioner seeks to have the person receive continued treatment in a secure residential recovery facility, the application must expressly state that. And just to tie this back into S89, if the commissioner seeks treatment at a forensic facility, it has to be expressly stated.
Katie, on page 11, probable cause review. in there it says that that review must take place within 30 days.
3 days.
3 days.
3 days of filing the AIT.
Yeah.
Okay. What if it doesn't take place?
Then they're out of compliance with the law, I'm not sure.
Does the person, if probable cause is not found, the person is discharged? So if they don't do that within 3 days, are they
As
discharged?
a result of the person is discharged automatically?
Yeah.
I don't have an answer for that.
A friend, Jack?
Jack McCullough from the Mental Health Law Project. No, in fact, the provision of the statute that mentions that 18 VSA section 7612A specifically says an application for involuntary treatment shall not be dismissed solely because the probable cause review is not completed within the time period. It is good cause for the delay. But, you know, it's printed, in the forms that the Department of Mental Health files for an application for involuntary treatment. There's a line printed on the form for the judge to sign off that says, I determined that there's probable cause. And so as it comes to the judge, it's right there for the judge to review the paperwork and sign. When this was originally put into the law, there were Judge Teachout would occasionally kick these back to the AG's office and say, this is illegible. I can't even read what you've written here, so I can't make a determination of probable cause. But I can't remember the last time we've seen where probable cause was not found.
Thank you.
Okay. So we were on,
So wait, I'm sorry.
Yep.
So you were tying us back to S 89,
Yes.
which we will be looking at again tomorrow. S 89 is the forensic facility. So that would fall into place here where Commissioner of Mental Health would say forensic facility, but at this point in time, we don't have a forensic facility.
this is sort of where that piece would be inserted and how it would relate.
This language would only be for the application of continued treatment, and it would be for the underlying application too with regard to the forensic facility.
The difference, do you want the difference?
Yes.
The difference is that a person going into the secure residential recovery facility can only come from a hospital setting. So they can only come in under an application for continued treatment. It can't be their original underlying application for treatment. Whereas the language proposed in S89, the person's initial order under the custody of the Commissioner of Mental Health could be to the forensic facility. So this language has to apply or appear in both places for that to operate that way.
And I thought to access the forensic facility was through the criminal,
Yes.
and this isn't necessarily criminal.
This is.
It's,
It could be, yes. So remember the chart I showed you, the first chart, and I showed all the different boxes coming into a hospital. So one of those boxes was a forensic population. So individuals criminally, with some kind of criminal justice involvement would come through. So Title 13 sort of, I don't know what the right word is, sort of refers people who are in need of treatment under the custody of the Commissioner of Mental Health to the statutes in Title 18. So folks that are coming in the criminal justice door are eventually sort of following this same process under Title 18 as people who are not coming in through the criminal justice door.
so to clarify my question,
Yeah.
could someone that's not, gets into this not through a criminal process end up in forensics?
No.
Okay.
So the language in the bill specifies that you have to come in through the criminal justice door to be in the forensic facility. But we have to amend, in order to make that happen, we have to amend Title 18 because that's where the commitments are happening. Yeah.
So now what happens, if you know, they've gone through the right door and they end up in the unit, the forensic unit.
Okay.
What happens to them? When does treatment take place?
Should we do that now or tomorrow? I'm just wondering if I'm,
I don't know.
okay, if I'm getting us off track.
Put myself in the person's
Yeah,
shoes and.
So
okay,
if you can do a
big picture, okay.
and then dig down tomorrow.
So maybe I'll bring you to the end of my presentation again.
Revisit it tomorrow, right?
But,
Revisit it.
We're with 89 tomorrow, so sometimes it's good to hear it twice.
Oh, I
so a person who's coming in through the, trying to think, so they have to have an application. So a person, S89 is drafted, the person is coming in through that forensic door. Do you see the first dot all the way to the left? And there are three sort of arrows leading into it, and one of those is forensic. So those individuals are coming in through the forensic door. And then they're sort of being subject to the same proceedings as everybody else who's come in a different way. So, and it would be the same timeline for getting treatment as anyone else.
And I think that some people who want the forensic facility would say, if they're not in a forensic facility, they may not be getting the treatment they actually need. If they're actually in jail, they may not be getting the proper treatment.
They're definitely not getting it.
Yeah. But in the forensic facility, that is the place for them to obtain the point to
Where they should
have
get
it, where they should be getting the treatment.
and that's, I don't know which one is 89 or this one. That's my concern about people that are intellectually disabled.
So I'm gonna pause you there because this is just a process for individuals with mental illness.
Right.
This is not the process for individuals with intellectual disability.
And I can also tell you, Human Services gave extensive testimony today on S89 for that
So it's in the-
population. Yes. So that's in S89 and that's in Human Services.
Okay.
Yeah. But they are taking extensive testimony.
Can we hear a little bit about that tomorrow anyway? Just how they interconnect when we hear about.
If we have any information from them, I'm not sure when they'll be ready to say what they're doing. All right.
Okay.
Yeah, getting back to the theory of S47 and the transport. If there's a facility in the area of wherever this takes place, it's different than a hospital, but applicable to someone with a mental health issue. They can be brought there, can they not? Or must they go to a hospital?
I don't think the language says a hospital. I've drafted it a couple different times and I'm not sure what it says, but at least one draft had said police barracks could be an appropriate place to take the person
In transport, huh?
for the warrant transport.
Really?
Safe place, isn't that what it's?
There's three
Safe
things I
place.
just.
I have to look at the language and I'm getting confused what's in the bill and what's in the underlying language.
Okay.
Hospital, police barracks, or another safe location.
Okay,
That's
so
the underlying,
hospital,
or is that the
police
bill?
barrack, or another safe
That's the bill.
location.
It's very open-ended.
Is that the green part?
Well, if you bring them to a police barracks, it almost sounds like that's temporary, and then they would have to be transported to a place where they could be evaluated.
Yes.
Okay,
That's right. So that's part of S47, which is.
right, I'm trying
So
to,
it's temporary custody in a safe place. And then filing for the warrant and then transporting them to where they need to go.
right, okay, but what I'm saying is, when they get transported, the warrant's been applied for, and now you're transporting, must they go to a hospital, is what I guess I'm after.
Well, I think once the warrant is
That's the one.
agreed to, right?
Once there is a warrant, the person is to be evaluated.
Okay, and is the only place they go in a hospital the emergency room, or can they go to if there's a separate unit in the hospital that handles that kind of thing? I'm just.
Yeah, that's not Katie's. I don't think.
The answer might be different hospitals,
That's fine.
different locations, I'm not
Trying to get the
sure.
whole thing together.
Brian, did you want to?
Well, the way I might frame this is, when a person has a mental illness and the risk they pose to themselves and others is so high that multiple people in the community working as a team determine that their rights need to be restricted to keep them safe and get them treatment. The way I would put it is we try to get them to the place that makes sense. It might be a police station, it might be a hospital or another safe place. I could see situations where people have been creative to stabilize a person. But ultimately, you're trying to move a person into the healthcare system. So usually the ER is the landing point.
Okay,
And then
there's
from
the
there,
landing point.
and then from there you'll go to like the Vermont, I don't know what it's called now, so forgive me, this hospital, the Vermont.
Psychiatric care.
I would just look for,
Hospital and-
avoid the clutter of an emergency.
Yeah. These are people, this is situations that are appropriate for the emergency room, I would say, like, what, I would say, I don't know, maybe down the road, urgent care could be used.
Okay.
But I feel like when someone's, it would be good to go do a tour at some point and of emergency rooms and let people see, like if you came to the emergency room I work in, you'd see, even just walking through the hall, you'd be like, wow, why are there 20 people in that hallway? And we'd be like, because there's 3 patients in there. And those 20 people, there's a sitter for each room, there's 2 security for each room, there's a cop, you would see how many people it takes, like.
Yeah.
So I didn't know, are you through?
I am not.
Okay. All right, let's
I
keep going.
can see if you.
Nope, let's keep going.
Process never ends.
I know.
We cry uncle, isn't it?
This is one of the most complicated
Yeah.
processes I've ever worked with in healthcare, though, so it's good for me even to have you doing the review. Yeah, it really is.
So we read the application for continued treatment. The court has a hearing on that application, and then we have various outcomes. So the court doesn't find that the patient is a person in need of further treatment. The person is discharged.
The court does find that the person is a patient in need of further treatment and requires hospitalization, then hospitalization can be ordered for up to 1 year. If the court finds that the person is a person in need of treatment and does not require hospitalization, then we have the order of non-hospitalization for up to 1 year. There's some language about if there's non-compliance with the ONH or if it's inadequate to meet the person's need, then the court can revisit and order an order of hospitalization or modify the original order of non-hospitalization. So this sort of takes us back in time a little bit, but this is sort of the specific language about individuals coming in through the criminal justice door. So if a party or the court makes a motion for an exam, so this is individuals who are in the criminal justice system, there's a mental health screening that's completed while the defendant's still at the court. The court may order inpatient examination in light of the screener's recommendation. The court before which the defendant is tried or to be tried for a criminal offense must hold a hearing to determine if the defendant should be committed to the Commissioner of Mental Health. And if so, then the defendant, if the defendant is found by the examining psychiatrist to be insane at the time of the alleged offense, found incompetent to stand trial, not indicted by grand jury due to insanity at the time of the alleged offense, or acquitted due to insanity at the time of the alleged offense. Those are situations in which the person would likely be transferred. So that kind of addresses your question of how the transfer happens. And then there's this chart on forensic admission and commitment. I won't walk you through all of this, but you'll sort of see that at the bottom here, this is where you would get your order about a forensic facility, this order of non-hospitalization. So in your free time, you can study this chart.
And where's the long trailer?
So I should pause and say everything I've just, what do you want me
No, go
to
ahead.
just pause in general?
Yeah, you're good.
Everything I've just talked about is getting the person to receive treatment in a hospital. Once the person is in a hospital, the commissioner, the providers might determine that the person needs involuntary medication. Up until this point, there has not been involuntary, non-emergency involuntary medication. So there is a whole court process for that, which it's in S89, which is, well, you can decide?
Yeah, all right, we should go through it.
Okay.
Yeah.
Are you sure? I can give you a high level.
Yeah, no, let's go through
Okay.
it. We're just gonna have to hear it tomorrow.
Okay.
Yeah.
The Commissioner of Mental Health could file an application for involuntary medication if the person is refusing to accept psychiatric medication, if one of the following circumstances is met. I'm not going to go through these circumstances, but all of these are circumstances. There are sort of six, these columns are each six conditions under which the commissioner can apply to have involuntary medication, and all of this involuntary medication will be given in a hospital setting, which is important because when you think about the forensic facility, you're creating sort of a seventh column on this chart, and that would be for involuntary medication outside a hospital setting in the forensic facility. There's language on this slide about how the application for involuntary treatment and an application for involuntary medication in certain circumstances could be consolidated. This is what is in the application itself. So the nature of the person's mental illness, the person is refusing proposed medicine, the person lacks competence to decide to accept or refuse medication, the necessity of involuntary medication, the proposed medication itself, the risks and benefits of the proposed medication, the person's prognosis with and without the proposed medication, person's health and safety, current relevant facts and circumstances, including history of treatment and medication, proposed alternative treatments and reasons for ruling them out, and whether the person has executed an advance directive.
Sorry, did you say who fills this out?
The treating physician.
Oh, so it doesn't have to be psychiatrist?
That's an interesting question. I have treating physician, but I need
Because it
to.
seems pretty complex for
I would
ER
check.
person. Yeah.
And it could be that what is in statute might be different than what is happening in practice. I need to check the statutory language on that. Then there's a hearing on the involuntary medication. So the commissioner has the burden of proof by clear and convincing evidence. And then there's the court looks at competency. So in determining whether the person is competent to make a decision on medication, the court shall consider whether the person is able to make a decision and whether the person is able to appreciate the consequences of that decision. And the court must suspend a hearing on involuntary medication and enter an order authorizing the commissioner to provide treatment to a person as allowed under an advance directive if the court determines that the person is refusing to accept medication, the person is not competent to make a decision, and the decision regarding proposed treatment is within the scope of a valid advance directive. If hospitalization is necessary to effectuate the proposed treatment, then the court may order hospitalization.
I just want, before we go too far ahead, I wanted to just highlight something you said. Earlier, you said non-emergency involuntary medication. Can you talk a little bit about what involuntary medication is allowed under the law for emergencies right now? Because people may have seen in the news about like EMTs injecting black kids with ketamine in Burlington, and there's been some stuff that's gone down that hasn't been so great. So I don't know if you could speak to what's legal or.
The second time this has come
Up in committee today.
The same incident or?
No, just talking about emergency involuntary procedures. So I have a chart
that I can send to you and maybe is an easier way to look at the difference. But there's also emergency involuntary procedures, seclusion and restraint. And restraint can be physical restraint or chemical restraint, meaning medication. Those are used in emergency situations. They are not court ordered. And it's not specific to individuals who are receiving mental health treatment. It could be used in other treatment situations. And whereas involuntary medication that we're talking about here, it's non-emergency medication. It requires a court order, and it's used in a mental health treatment setting.
Leslie?
I'm a little confused about how advanced directives fit in here, because that's a whole nother land of decision-making and competence. And that's confusing to me.
So this is part of the statute, that this is one thing that the court will look at. It will determine whether somebody has previously filled out an advance directive, that if they are not competent to make a decision about medication, that they may say, if I'm not competent and my provider thinks I need medication, then I would like to be given medication.
But I'm interpreting advanced directives to mean end of life care. Does it mean something else?
Oh, there are
Oh,
advanced.
there's a whole other land of advanced directives and that I don't know about. Got it.
Yeah. If you tend to,
If I could add what I would think, Katie's right, one thing that the person could say in an advance directive is, here's my preference for the kind of treatment I would like. I don't want Haldol, but I would like Disperidone.
Oh, so it's for psychiatric treatment and it's not end of life care. So it's
Well,
used.
it could be all of those things.
Oh, okay.
But someone could also, if they're competent, say that I direct that if I become incompetent to make a decision, that I will not accept any psychiatric medication. And if they do that, and that's in their advance directive, then that is binding on the courts and on the hospital. So someone can say, I'm not getting psych meds, period.
So that's refusing treatment.
Yeah, they can do that.
Okay, so that's what the advance directive is saying, I'm not going to get any psychiatric medicine at all, period.
You could do that, yeah. And of course, that doesn't change the fact that you might be stuck in a hospital for a long time if you're not accepting medication. But it does happen, and just in 2019, I had a case in the Vermont Supreme Court in which they affirmed exactly that.
Thank you. Daisy?
Sorry. Do you know if, so I just want to be clear, you don't have to answer. Just, it's not just because you're asking the question, but it kind of goes for everyone.
if training on advanced directives is built into any clinical workflows in our DAs and SSAs.
Like for Dylan Burns, mental resources director from our departments, we do talk about advanced directives quite a bit in terms of specific training. Like you're talking about how to support a community and make things like that. That kind of.
Yeah, I know in some states, it's actually built into the EHR. It kind of is electronic health records. It's part of the clinical workflow. So every patient who has a certain diagnosis has an advanced directive, and that's built into the workflow. So that if you're treating someone for schizophrenia or bipolar or whatever, they have an advanced directive on file. So their preference for what happens if they need a certain medication is already there. So you have fewer situations where they're without a choice. They always have a choice, and it's on file.
I've seen that in the EHRs in our system, but I will be happy to get back to you on the question about the training and, it's required.
And then statute gives us a whole sort of hierarchy of how the court makes decisions, what the court is looking at. So if a person, in terms of making the decision on involuntary medication. So if a person is subject to a petition for involuntary medication, has an advance directive and certain criteria are met, then the advance directive sort of governs the decision. If the person has no advance directive, the court is to follow the person's competently expressed written or oral preferences regarding medication. And if a person has no advance directive or medical preferences documented, then the court would look at the person's religious convictions as pertains to the person's refusal of medication, the impact of receiving or not receiving medication on the person's relationship with family or household members, likelihood and severity of the medication's proposed adverse side effects, risks and benefits of proposed medication on person's prognosis, health and safety, and various alternative treatments available.
What happens if you have, I don't know whether it's called an advance directive or what it's called, but a person designated to make healthcare decisions for you?
Healthcare proxy. Healthcare proxy.
I did it with my daughter, my oldest daughter.
I don't.
So what happens then?
But I would think that they're two, if I may, two separate
I
kind
was
of.
gonna maybe wait for the ledge council to answer first, and then you may.
Okay, thank you.
Just in case she has a legal answer.
I don't have a great answer, and I would have to look into it and get back to you.
Because I think we're conflating two things, the more I'm hearing about this, is one is advanced directives that your daughter has for you, which is your basic care if you get pneumonia or whatever. And then this is psychiatric advanced directives, which seems like a whole other land, is what I'm learning. Well, I've never seen an advanced directive that I've come across that has psychiatric medication included.
They could do both.
I mean, I'm sure they could, but I don't think that's the standard, the norm in the world of, other than psychiatric world. That's what I'm wondering. It's all new, and I've seen many of them.
I think the answer is we don't know, and so Katie's gonna look into it and try and get back to us, and if you can't, we'll find someone else who can tell us.
You.
So let's,
Do you want me to try to answer Representative Fox?
sure, and then we're gonna keep it much more focused on this.
Okay, sure. As I understand it, the question is, what does the healthcare agent have the authority to do?
Yeah.
And it depends on what's in the advanced directive. The advanced directive could say, do whatever Topper says. Or it could say, here's the list of things that I'm willing to do, and things that I'm not willing to do. And so that's going to govern how that goes.
And the agent will just make sure that that's followed.
Yeah.
Okay.
Okay. So then we have the outcomes of this hearing. So if the court finds that a person is incompetent to make a decision on the proposed treatment and involuntary medication is supported, then the application is granted in whole or part with reference to supporting factors. The order specifies the medication type,
Permitted dosage, length, and method of administration.
and the order requires the provider to review the use of involuntary medication weekly. If the court does not make that finding, then the application is denied. And if the person who's subject to the order later becomes competent, then the order is no longer in effect. So we have language about length of the order. So if the person receiving the involuntary medication is hospitalized, the order shall authorize administration for 90 days unless the court finds longer time is necessary. The longer time is necessary cannot exceed an underlying order of hospitalization. And if the person receiving involuntary medication is under an order of non-hospitalization and the court finds that without the order for involuntary medication, there is substantial probability that the person would continue to refuse medication, consequently pose a danger of harm to self or others, the court may order up to 72-hour hospitalization to administer the involuntary medication. And I think I recall a conversation that this last paragraph is not used very frequently, if at all, but it is in statute. So let's see, if a court has authorized so this is the 72-hour hospitalization to administer the medication. I might skip over this. And then we have our timeline.
Thank you, Katie.
Thanks.
Welcome.
I think what I am taking away from this is one, we're looking at a lot of different things in committee over the next week or two that are interrelated, right? And then I think what's even more important is, S47 could potentially start the process for someone that goes through all of this. So I think back to Wilda where she says it's not just about transport. It's really not just about transport. It is taking someone in and saying, we think you're a person in need of treatment. And it could set them up for this long process. And, we need to make sure that their rights are protected. At the same time, we need to make sure that hopefully people are getting, the care they need at the right place at the right time. So just wanted to keep that out there. Any other final questions or Maury?
More of a comment, and it might be better for providers and others involved in treatment, but just wondering about where the 90 days came from and thinking about the time it takes for psychoactive medications to become effective, like in treating schizophrenia or manic episodes. Just to as a clinician, a curiosity.
Do you know, Katie, where the 90 days can come?
It has been around as past decade that I've been here, so it's been around a lot longer than that.
Anyone?
It's been around, Kristen Chandler, again, it's been around for at least 50 years.
50?
At least 50, yeah. And I'll just say that, you know, it's, while very few people get held for that length of time, because they get better and we have this least restrictive model. And so they get discharged, still on, still on their medication, if that's what's working for them.
Yeah, it seems like the effectiveness of medications happens a lot more quickly than 90 days. Some psychoactive, it takes a couple of weeks, 3 weeks maybe to reach full efficacy, but
Yeah, I can tell you the hard part is our system in Vermont where people get admitted. And used to be an average length of time before you actually ever would receive treatment. It was 54 days. And now I think it's shortened up a little bit given the advent of the change in the statute, but it's really hard for the families. When in Massachusetts, bordering states, this will not happen. While they're waiting to go through our legal process here, which is, it's rigorous. Their loved one is not receiving any treatment, that might be effective to help their symptoms. I shouldn't say any treatment. I mean, they're in the milieu of the hospital, they're in a secure place, but the treatment that might be more effective can't be given until a judge says it can be, if in the involuntary process.
thank you.
Daisy?
Just a question. I know it's not a Katie question.
Okay.
It's just a problem.
Let's ask it and we'll
Okay.
see where it goes.
Probably a Karen question. But it is definitely about process. So between a psychiatrist being needed somewhere in this process, it involving a hospital, involving a court and a judge. I see a lot of bottlenecks in this process, and a commissioner, needing commissioner's approval and request and signature. I'm curious if there's situations when that 72 hours is problematic for the individual, or when people wait to kind of prompt a request or something because they just simply know, like, it's a Friday, we're not taking this person into the ER, it's going to be wild in there. So like, how does the reality of this fit within this, like, what's realistically not a linear process on the ground, right? And I apologize because I know that's not a policy question.
Well,
it's a
Karen just popped up.
practice question.
So, Karen.
Hi, good afternoon. For the record, Karen Barber, General Counsel for DMH. Daisy, I'm not sure I completely understand your question because we were kind of in the realm of talking about involuntary meds, but then you started to talk about emergency rooms. So could you just restate it so I understand what you're asking?
I'm not talking about involuntary meds, but just the procedure for an individual getting an OH, right? So I'm looking at the bill specifically, and I referred to, the emergency room because I'm looking through at the language in the bill and the individuals involved, and I know how busy they are. And I referenced the commissioner and a psychiatrist and an emergency room, and I know all of those places tend to be bottlenecks and places that are hard to quickly move in and out of. And so with tight timelines like are listed in this bill and turnarounds, I wonder how the reality of this is out on the ground, because Katie's diagram was beautiful and linear, but I know that that's not how it works in reality. So can you give us, just being candid, are there situations where, we
this just isn't realistic. When I look at the bill, I want to, put forth something that's fair and reasonable to the way things are actually working right now, because what we heard from VCP was policy is not aligning with practice, right? And I mean, I want it to be something that goes out of here is reasonable for providers, but also fair for individuals. And Karen, I'm just curious from your perspective, the legal perspective, but also you are also wed with the commissioner's office and triggering some of those requests, which is why I wanted to hear it from you.
Yeah, so we've built kind of processes around all these things. I'll say long weekends, holiday weekends in particular, can sometimes be challenging for us. Back when I think I started in 2014, and I feel like one of the first things we did, I think that's when it added the second cert needed to be done within 24 hours. Most hospitals didn't necessarily have psychiatry coverage, so we contract right now with UVM, and we will with our future contractor to do second certs 24/7, so that we always have someone available to do those second certs. In terms of legal filing the applications, if it is a long weekend, if we're going into a long weekend, they assign one of their paralegals who is kind of able to make sure that we're meeting the 72-hour deadline. We always have folks on call at the department. So we're always, every time one of these comes in, there are eyes on and we're reviewing it. So, I mean, the deadlines are tight, but we have built processes around them to make sure we can meet them. I'd be lying if I said sometimes a second cert doesn't get done and we have to start the process over. But I think generally we have tried to build process around to make it feasible. Does that kind of answer your question?
Yeah, I mean, it's helpful to hear that sometimes it just doesn't get done, because I think that, I would suspect that that's true, but also, curious to hear what resources are missing that causes that, and that's helpful to hear.
Leslie? This is just a really quick question. I went back to Katie's very first slide with the bubbles. And the top two bubbles, I guess, is the emergency pieces. And I'm just wondering if we have a sense of how often this happens in a year, or do we have an idea of what we're thinking about here?
So you mean for the warrant process? So we did see the information for Chittenden County that Brandy Littlefield sent in her.
That was Chittenden County.
That was Chittenden County. So Karen, do we have an idea across the state?
I don't have exact numbers we could get them. We certainly do see a lot of warrants. I would say some areas, like especially in the Northeast Kingdom, we see quite a few. It does seem to depend on maybe the area and the designated agency's practice, but certainly they are fairly common. I would say probably more common than they were, a few years ago, but
well, I'm not interested in anyone having to do a lot of work. I'm just more interested in order of magnitude. Is it like 10 or is it 1,000? I mean, just to get a sense of scope, that's all.
So I can say I think when I pulled numbers the other day, I forget where I was testifying, but I think we had about 325 people total, maybe under the commissioner's custody. Those were a mix of OHs, ONHs, and those on EE status. So not all of those are coming in this direction, but that gives you kind of some numbers.
So statewide.
Mm-hmm.
Thank you.
Great. So thank you, Katie, very much for this. You'll be back with us tomorrow in S89, of which I believe we're going to have what the Judiciary Committee has marked up. And so we'll come back to that. That's the forensic facility. Again, we are only dealing with the mental health piece in this committee. And then we will find time to come back to S47. But I think this was really helpful it's still confusing, but I think it's helpful to kind of set the stage of what the whole process is like. I want to again thank those in the committee who we did not ask to come in and testify, but who came in and testified to help us with this conversation. Thank you very much. Thank you, Karen, for being here. And so I just want to do a quick committee thing, but we're good, Katie, if you want to head out, and thank you, everyone. So
thank you for bearing up.
We're still going to do 5 minutes here. So This is the time, I think everyone's got the email from the speaker's office that the schedule's gonna start changing tomorrow, Friday, and then next week. And so Friday, we'll, House floor at 9:30, conduct business, recess, not adjourn, recess, come back at 2:30, and that's to help keep bills moving. And then next week, it'll be 10 and 3. So we will be here 9 to 10 with chunks of testimony, and then we'll be here after floor before 3 with testimony on different things. We won't have any testimony unless, we have to finish something after the floor at 3. So just want to put that out there. And this is also the time where things can really change on our schedule too. So for instance, tomorrow we kind of didn't have much on the schedule, but Claire has posted an updated schedule. We'll be starting at 10 with Jen Carby to go over the radiologist bill that's coming back from the Senate. There's one small amendment. We will have to either concur or send back another amendment on that. And then we'll have Katie back at 10:30 for an S89 walkthrough. We'll have lunch, and then in the afternoon after the floor, we have Senator Vyhoski coming in on S65. We'll have a little conversation there. And at 3 o'clock, we have Ameren coming back from Ledge Council. Senate Health and Welfare voted out H206, which was a DEVA technical bill, but they have put couple amendments on it. So there'll be some testimony we may need to take there. So stay tuned to your emails, stay tuned to check the schedule every so often. I'll try and keep us up to date as we go. But again, things kind of change quickly. Tomorrow morning at 10.
10 o'clock instead of 9.
Yep, 10 o'clock instead of 9, so everyone can sleep in a little bit.
Darn rural cops.